Welcome to Young Legal Minds. As you know from the title, this video is going to be on consideration. So what is consideration? Consideration is the test of enforceability. It's what incurs legal right under a contract and renders the contract enforceable. So if consideration is not given, then the contract has no legal weight and cannot be enforceable. There's no set definition of consideration, although its meaning has been described in various case law. In Korean Misa, or Korean Misa, however you want to say it, consideration was held to involve a benefit and/or a detriment, and usually both occurs in a contract. So, for example, in the sale of goods, there is a benefit and a detriment to each party. The seller loses a product by selling that product, so that's the detriment, but gains money from selling that product, so that's the benefit. The buyer loses money, that's the detriment, but gains what he or she wanted, so that's the benefit. Or for example, in a contract of service, let's say you pay somebody to paint your garden fence. You lose money by paying them for that service, which is a detriment to you. But you receive a service, your garden fence is painted, so you receive a benefit. And the painter receives a detriment by having to use his paint, which he most likely had to spend money on unless you provided it. But he also suffers a detriment by having to commit to the rigor of painting a fence. Yet he obtains money from providing that service, and so there's a benefit and a detriment to him. Sir Frederick Pollock, however, defined consideration as the price of the promise. This definition has been accepted by the courts because it emphasizes a give and take, a mutual exchange of consideration. It reflects the substance of consideration. Furthermore, in the case of Dunlop Pneumatic Tyre, it was held that consideration is an act or forbearance of one party, or the promise thereof, is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. So, as you can see, there's no set definition of consideration, but its meaning is always the same. It involves some sort of mutual exchange, and it's to be construed according to that meaning. There's no set definition, but the substance of consideration is what's important. And in order for consideration to be valid, there must be certain requirements that are met. And oftentimes, what can seem like consideration will not actually amount to valid consideration, and vice versa. The first thing the courts will look to was whether the consideration provided was sufficient, because the rule is that consideration must be sufficient, but it does not need to be adequate. You could say, but aren't sufficiency and adequacy just synonyms? Can't those words be interchangeable as they mean the same thing? Well, no. In contract law, when we refer to sufficiency, we mean legal sufficiency. If consideration is adequate, it simply means it was proportionate to the other party's promise or consideration, and it does not need to be the latter. It does not need to be adequate. It only needs to be sufficient under the eyes of the law. If it is not sufficient, then the contract will not be enforceable. It's often been said that providing a peppercorn as consideration is sufficient. If you want to sell a Ferrari and in exchange you happily accept a peppercorn for that Ferrari under the contract, then the party who provided that peppercorn provided valid consideration. And that the contract will therefore be enforceable. So it's quite wide and quite extreme, but it reflects the self-regulatory nature of contracts, because the courts are adamant to interfere with a person's right to contract on the terms that they wish to contract on. So this is essentially why consideration does not need to be adequate. In other words, it does not need to be proportionate. It must only be legally sufficient. And the case you'd want to use to support that principle is the case of Thomas and Thomas, where a woman was allowed to stay in her home for just £1 ground rent. That £1 is not proportionate to the property. No house is worth £1, so it was not adequate, but it was legally sufficient and amounted to valid consideration. The case has quite absurd facts, but nonetheless, it is the epitome of this principle. The principle probably also reflects what's known as caveat emptor, i.e. buyer beware. The law encourages people to be very mindful of the contract they're entering into and the terms in which they are going to be legally bound by. And so it doesn't really matter how trivial the consideration is, the consideration that's provided, no matter how disproportionate it is, given that it's legally sufficient, it will be able to enforce a contract. So, for example, in the case of Chappell and Nestle Co., chocolate bar wrappers amounted to sufficient consideration. If you want to know more about that case and why on earth chocolate wrappers were given as consideration, then you should read the facts of the case, because consideration is also largely contextual. The reason it was held to be consideration was because the company promised to provide music records if a person sent in a certain amount of chocolate bar wrappers, and that's why it was held to be valid consideration. Not only must that consideration be legally sufficient, but it must also have some economic value. So, in the case of White and Blewett, there was a dispute between a father and a son. The father wrote a will. The son was not happy with how the father intended to distribute his money when after he died, and the son owed his father money. So the father promised not to enforce the debt if the son stopped complaining about how the money was intended to be distributed when the father dies. And then eventually the father did die, and the executor of the father's estate wanted to enforce the son's debt. The son tried to argue that by not complaining about the way the father distributed his money within his will, that he had provided sufficient consideration, thus rendering the debt no longer enforceable. The court, however, held that the debt was enforceable on the basis that no valid consideration had been given. The son provided because the consideration had no economic value. There was another reason for this, however. In his judgment, Lord Pollock said, and I quote, "It is said that the son had a right to an equal distribution of his father's property, and did complain to his father because he had not an equal share, and said to him, 'I will cease to complain if you will not sue.' Whereupon the father said, 'If you will promise me not to complain, I will not sue.' If such a plea as this could be supported, the following would be a binding promise. A man might complain that another person used the public highway more than he ought to, and the other might say, 'Do not complain, and I will give you £5. It is ridiculous to suppose that such a promise could be binding. The son had no right to complain, for the father might make what distribution of his property he liked, and the son's abstaining from doing what he had no right to do cannot be valid consideration." So there are essentially two reasons as to why the son had not provided valid consideration. Firstly, it was of no economic value, and secondly, he had no right to complain in the first place. So keeping his promise could not amount to valid consideration. The former reason being the most important one, the latter merely having implications for future analogous cases. And sometimes this principle can cause confusion, because in a contract of service, for example, going back to my example about paying somebody to paint your garden fence, can their action of painting that fence be said to have economic value? Well, yes. It's a service that most people who wanted their garden fence to be painted, that didn't want to do it themselves, would pay for. The action of painting the fence itself is not the same as providing money, but the service is worth money and thus has economic value. So, in Chappell and Nestle Co., even chocolate bar wrappers amounted to having some economic value. But you'd think they wouldn't. You'd think that chocolate bar wrappers wouldn't have economic value at all. Well, they may be worthless, but in this case, the reason the chocolate wrappers were held to have economic value is because they were supposed to be exchanged for musical records. So it was the wrappers were analogous to a monetary payment. However, ironically, in the case of Lipkin, gambling chips were held to have no economic value. Consideration must also move from the promisee. So what this means is that the party that wants to enforce the contract must have provided valid consideration themselves. And the case you can use for this is Tweddle and Atkinson. In Tweddle and Atkinson, a father and a father-in-law contracted with each other. They made an agreement that they would pay the father's son £100 each. So £200, and so the contract was between the father and the father-in-law. However, the father-in-law died and the son then tried to claim for the £100 from his estate. However, it was held that the son had provided no valid consideration. He was the promisee who wanted to enforce the contract, but he couldn't do so because no consideration had moved from him. And this goes back to my point earlier when I said that consideration involves some form of mutual exchange. If there was no mutual exchange, so it has to go both ways, both parties have to, make some exchange. If that did not happen, if only one party provided consideration and the other party tries to enforce that contract, they can't do so because they have not themselves provided valid consideration. So they have not provided, that enforceability, that element of the contract that allows for it to be enforced. But what about situations where, let's say, party A supplies goods to party B or carries out work for party B, who then afterwards, after that service has been provided, promises to remunerate that supply of goods or services? So the question is, can past consideration enforce that promise? Is past consideration valid consideration? Generally speaking, no, it isn't. As shown in the case of Ross Scola and Thomas, and confirmed in the later case of Ree Mercado. There is, however, a general exception to this principle, as with most principles in law. In the case of Pao Wan and Lao Yi Long provides this exception. It consolidates the law on this issue. It gives a three-stage test that, if satisfied, will render a contract enforceable despite the consideration being past consideration. And it provides that past consideration may be able to enforce a promise given if the past consideration had been provided at the promisor's request, as shown in the case of Lampley and Braithwaite. So look at the case of Lampley and Braithwaite, read up the facts of that case and the outcome. So going back to my garden fence example, if you ask somebody to paint your fence and later promise to confer a benefit on them or remunerate the act through monetary payment, the past consideration the other party provided may be able to enforce your promise. Secondly, if the parties understood that the act was to be remunerated, then the past consideration can be valid consideration, as shown in the case of Ree Casey's paintings. Look at the facts of that as well. There can actually be an implied understanding between the parties. This element of past consideration is very contextual. Let's say I make a living from painting garden fences. It is implied that payment will follow, even if I don't necessarily give a quote beforehand. If I did give one, it's pretty obvious that payment should follow. So it can be implied. If it was expressed, then it can. Then past consideration can definitely amount to valid consideration. And last, payment or conferment of a benefit would have been enforceable had it been promised in advance. So that's the exception to the general rule that past consideration is not valid consideration. So the cases Pao Wan and Lao Yi Long, and the two cases within that case within the exception are the cases of Lampley and Braithwaite and Ree Casey's paintings. But what about existing public duties? Can performing an existing public duty amount to valid consideration? Well, in the case of Collins and Godfrey, a payment was offered to a witness to give evidence in the trial, and the judge held that giving evidence in the trial would not amount to valid consideration on the basis that by doing so you were only doing what you have a duty to do. It's a public duty, and so there's a lack of consideration provided. In fact, there's no fresh consideration provided. Cases such as Morgan and Palmer, however, suggest this principle has to do more with public policy than it does with consideration. There is, however, an exception to this rule as well. If you cede your existing public duty, that may amount to valid consideration. So, in the case of Ward and Bytham, a father promised the mother of their child money if she kept if she kept the son well looked after and happy. Now this is somewhat ironic, but the courts held that by keeping her child well looked after and happy, that she exceeded her existing public duty, as her duty was to keep him looked after, not necessarily well looked after and happy. And in keeping him well looked after and happy, it was held that she exceeded her existing public duty, and so that enforced the father's promise. I'd be careful using this case though, because the judges were criticized for ignoring that consideration must have some economic value. Perhaps the father, felt at ease knowing that his child is well looked after and happy, but peace of mind has no economic value. The case was decided by Lord Denning though, and every law student and practitioner knows that Denning was a rebel that always went against the status quo. So yeah. And the thing with this case is that it contradicts the case of Eastwood, where it was held that moral obligations are not consideration. In this case, the claimant was the guardian of a minor, and he used some money to improve her property and pay for her education. When she grew up, she promised to pay him back, but it was held that his actions did not amount to valid consideration. Contrasting this with the case of Ward and Bytham, where the mother apparently exceeded her duty by keeping her child well looked after and happy. But in Eastwood, didn't the carer exceed his duty by paying to have her property improved? Instead, I would probably use the case of Harris and Sheffield United FC to support the exception to the general rule. In this case, there were a group of policemen who were paid for extra services. They were paid to conduct lengthier patrols, more frequent and consistent patrols, and it was held that they exceeded their existing public duty, and so in providing extra service, they provided valid consideration to enforce the promise of payment. But what about performance of an existing contractual duty owed to the same promisor? Can that amount to valid consideration? Well, Stilker Myrick provides the general principle, and that principle is that generally performance of an existing contractual duty owed to the same promisor is not sufficient consideration. It provides no fresh consideration for a promise. And Stilker Myrick, what essentially happened was there was a captain of a ship, and they then took refuge on a small island, and then some members of the crew went missing. They didn't return. So what the captain did was, actually it wasn't the captain who initiated this idea. The crew members then put pressure on the captain and essentially said to him, "We will sail the ship back if you give us an additional payment." So the captain agreed. The salary of the missing crew will be divided between you. It was actually held to not be valid consideration because what the crewmen were doing by taking the ship back was merely an existing contractual duty, so they provided no fresh consideration. However, you also need to be aware of the policy considerations in this case. It was during the war. They were abandoned in enemy territory, and the captain had no reasonable alternative other than to have the ship sail back, and he was unable to find replacements. So this would have largely contributed to the judge's decision. There's another reason this happened, and that's economic duress. There's another reason. Economic duress is one of the other reasons why it was held to be insufficient consideration. We're going to go on to that in just a moment. But as with most general principles in consideration, there is an exception to this rule too. In Hartley and Ponsonby, essentially the same facts happened. They were the same facts. Some crewmen deserted their ship, but it was held that in promising a payment to take the ship back, fresh consideration had been provided. There had been valid consideration, and this was essentially because the shipmen had to take on duties they would not normally take on, the duties of the missing crewmen essentially. Not only that, but the weather conditions made it really difficult. the danger of an accident happening was at an all-time high, and this was not during wartime. So it was held to the captain's promise of additional payment was sufficient consideration, because so many of the crewmen left that sailing the ship back was just of such a high danger. The other exception to the general rule is that if performance of an existing duty conferred a practical benefit on the other party, then performance of an existing contractual duty may amount to valid consideration. So in Williams and Roffey, for example, the defendants entered into a contract with a company that was to refurbish their flats. The defendant then subcontracted the work to the claimants. The claimants then got into financial difficulties and claimed they would not be able to complete the work by the date they agreed, which would have been detrimental to the defendants, because there was a penalty clause for if the work wasn't completed on time. And so the defendants then approached the claimants and promised an additional payment in exchange for their promise to complete the work on time. The claimants tried to enforce that additional payment, and the defendants argued that they were merely the claimants were merely doing what they were contractually obliged to do, and that payment should therefore not be enforceable. The court held that the claimants were entitled to this additional payment because they conferred a practical benefit on the defendants. This is for two reasons. Firstly, the work was completed on time, and so the defendants did not need to go to the effort of finding and paying other contractors to complete the work, and they can lease the flats out on time, and they also avoided the penalty that they would have to pay under the penalty clause, and so performance of the existing duty amounted to sufficient consideration. Also, a very important criteria was set out in the case of Williams and Roffey, known as the Glidewell criteria. This provides that where Party A enters into a contract to complete work for or supply goods or services to Party B in return for a payment, if during the course of that contract, before A has fulfilled their obligations, B has reason to doubt whether A will complete the work on time or complete it at all, and as a result promises B an additional payment in return for A's promise to perform his contractual obligations on time, and as a result of the promise, B obtains a practical benefit or avoids a disbenefit. And if B's promise was not given as a result of economic duress or fraud on part of A, then the benefit to B or the avoidance of a disbenefit would amount to valid consideration. So this is the test you use when tackling an issue in relation to performance of an existing contractual duty. Notice how it says that it must be in the absence of economic duress. So if economic duress was present, even if a practical benefit was conferred on B, it will not amount to valid consideration. So what do we mean by economic duress? Well, going back to the case of Stilk and Myrick, a report indicated that economic duress had occurred in this case. The only way to get the ship back was to promise the crewmen an additional payment. The crewmen were prevented from obtaining that additional benefit on the basis that they had refused to sail the ship back unless they received that payment. They essentially held their captain to ransom and used an improper method to obtain an additional benefit, so economic duress was present. The difference between Stilk and Myrick in the case of Williams and Roffey is that economic duress was present in the case of Stilk. In Williams, the defendants approached the claimants and offered them the additional payment, unlike in the case of Stilk, where the crewmen directly and specifically put pressure on their captain. So this is the difference between the two. Williams and Roffey, however, can be criticized, and the reason why is because it essentially provides that if you do something which you are contractually obliged to do, that can amount to valid consideration simply because you confer a practical benefit on the other party. And this includes something as simple as completing work on time. We need to ask ourselves, is that really, is that right that you can provide valid consideration simply by performing your work on time, because by performing your work on time, you provide a practical benefit. But isn't that something which you are obliged to do? Isn't this principle from Williams and Ruffy somewhat contradictory. If you raise that issue in the exam, you're going to hit higher marks. But what about performance of an existing duty owed to a third party? Can that amount to valid consideration? Say, for example, you contract with a party to complete work on time, and then say somebody else pays that party you contracted with to complete that work on time. The question is, can performing the existing duty owed to you mean that the party who owes you that duty, can they enforce the payment from the other party? Now, there are three main cases on this. There's Shadwell and Shadwell, there's Scotson and Pegg, and there's the Ury-Meaden case. The first two are largely criticised for a number of reasons, so I'm just going to stick to the Ury-Meaden case. But if you want to understand Shadwell and Scotson and Pegg, then by all means do some research on them. It can help. Now, in the Ury-Meaden, a contract between some shippers and some carriers contained an exclusion clause which excluded liability of the carriers if any cargo on the ship was damaged. Now, the carriers entered into a contract with the firm of stevedores on the basis that the stevedores would unload the cargo, and the shippers told the stevedores that they could also rely on the exclusion clause. And when unloading the cargo, the stevedores damaged the cargo, and the question was raised: could they rely on the exclusion clause, as the shippers told them they could? The court held that the stevedores had provided valid consideration, as the shippers received the benefit of being able to enforce an obligation on the stevedores, the obligation being to unload the ship. So in other words, the stevedores, who were merely performing an existing contractual duty owed to the carriers, had provided valid consideration to support the promise of the shippers. So performance of an existing duty owed to a third party can amount to valid consideration if the promisee obtains the benefit of a direct obligation that he can enforce. And this is even in the absence of a contract, because the first contract was between the shippers and the carriers. The second contract was between the carriers and the stevedores. So there was no contract between the shippers and the stevedores, yet the stevedores could rely on the exclusion clause because the shippers had the benefit of being able to enforce an obligation against them. And this was extended to promises of an existing duty owed to a third party in the case of Pa Wan and Lao Yi Long. So a promise of an existing contractual duty owed to a third party will amount to valid consideration. It's important to note that in Pa Wan and Lao Yi Long, Lord Scarman held that if one of the parties used economic duress or fraud to obtain a promise from a party, then the courts will not enforce the promise. So the regular economic duress rules apply here too. So that's everything on performance of an existing duty. That's performance of an existing public duty, performance of an existing contractual duty owed to the same promisor, performance of an existing duty owed to a third party, and promise to perform the promise to perform an additional existing duty owed to a third party. So now we shall move on to part payment of a debt. So, what is part payment of a debt? Part payment of a debt is exactly what it says it is. It's where you only partially pay your debt. You don't pay the full debt. So, let's say I owe you £100 and instead I pay you £99. That would be part payment of a debt. Now, the general principle on part payment of a debt derives from Pinnell's case, which says that part payment of a debt is not valid consideration, which was confirmed in the later case of Folkes and Beer. So, if I owe you £100, it does not matter how much I pay you. If it is below £100, even if it is £99.99, that is not sufficient consideration because it is only part payment. The logic behind this is that if you only pay a part of your debt, then firstly you have provided no fresh consideration to support a promise. You've provided nothing new. And secondly, you are only doing what you are obliged to do, and that is to pay off your debt. However, Pinnell's case does provide exceptions to this general principle. It provides that if you confer some article or property of some sort, whether it be a phone, a coat, food, whatever, if you confer that on the creditor, on the party you owe the debt to, and if they accept it in full satisfaction of the debt, then that will amount to valid consideration. At first this seems illogical, because it means that if I owe you £100 and I pay you £99, then that is not sufficient consideration. But if I owe you £100 and you accept something from me, such as, let's say, I don't know, a pen, in full satisfaction of that debt, then I have provided valid consideration and I can enforce your promise. The logic behind this is that I have conferred to you something that you are desirous of, something new. You have received a benefit. Well, couldn't you argue then that part payment of a debt confers a practical benefit and thus should amount to valid consideration? Well, this issue was raised in the case of Reselect Move, where it was held that part payment of a debt confers no benefit on the creditor, so the Williams and Roffey principle will not apply. Pinnell's case provides another example of when part payment of a debt can amount to valid consideration. Let's say we agree that I will pay you in Nottingham. I'll pay my debt off. I'll pay it off in Nottingham, but instead I pay you somewhere in London, part payment of the debt in London, and you accept that on full satisfaction. Then under the eyes of the law, I have exceeded my duty and have provided valid consideration. Personally, I don't understand this. I mean, it could be argued that you can use that money for travel costs, and so this is why it's valid consideration, but personally, I just fail to see the logic behind this. Giving you some article or property, I can understand, because it's something that, you know, some tangible item that you desire, and have conferred that upon you. You've accepted it in full satisfaction, so I have provided something new. I provided fresh consideration. But personally, I just can't see the logic behind the fact that part payment of a debt in a different place will amount to valid consideration. And that's probably something I'll mention in the exam in May, if consideration and part payment comes up, and if it relates to the issue of the scenario. Now, as I said, the general principle is that part payment of a debt is not valid consideration. This is a matter of public policy. It prevents debtors from exploiting creditors who are in an unstable financial position. So, for example, in the case of D&C Builders and Rees, the claimant had carried out work for the defendant for a certain amount of money. The defendant, however, knew that the claimants were not doing very well financially. So she told them she will pay them less than what they actually charge. And because of their unstable financial position, they accepted the part payment of a debt. Later on, however, they were entitled to recover the full amount. And this is why part payment of a debt is not valid consideration. It protects creditors. Now, the general rule in Pinnell's case and Folks and Beer creates a problem, quite a harsh one. Let's say that you are in debt. You owe me £1,000. I will probably send the boys round to break your legs. No, I'm just joking. But let's say you owe me £1,000 and I accept £500 from you as consideration and discharge you of your debt. What if at a later date I attempt to claim the remaining £500 from you? Well, I can, because part payment of a debt is not valid consideration. So you can see how this creates problems. As the promisee, you are going to rely on my problem not to enforce the debt. Yet, I can enforce it. I can go back on my word, which seems somewhat unjust. So the general principle on part payment of a debt can operate quite harshly on those who relied on the promissor's word not to enforce the debt. And this is why the equitable doctrine of promissory estoppel was created by the famous Lord Denning, to rectify the harshness that can happen at the common law level. Promissory estoppel is a topic I'm going to cover in another video, otherwise this video will end up being 2 hours long. Promissory estoppel is a beast of its own that needs to be tamed in a separate video, so be on the lookout for my video on promissory estoppel. Thank you for watching or listening even.